going to have a panel discussion with distinguished speakers from various paths of life and from various regions to discuss a very topical issue in connection with the 70th anniversary of the 1951 Refugee Convention. The 1951 Refugee Convention is universally accepted to be the cornerstone of international protection and the main instrument for the protection of forced migrants, or a subset thereof, meaning refugees. It does not aspire to be an all-encompassing instrument. If you read the statements of the Conference of Plenipotentiaries, they were themselves very well aware of the fact that the Refugee Convention was not extending protection to all the persons who might be conceivably called refugees and who might be conceivably deserving of protection. Still, the Geneva Convention was meant to be the main instrument for the protection of refugees. And one of the great endeavors throughout its long years has been to keep it relevant and to keep it inclusive in the face of ever-changing realities of displacement. And over time, the Geneva Convention has come to be complemented by a number of regional systems, which were never meant to supersede it or to displace it, but rather to give it effect in particular regions and to complement it so as to better accommodate the realities of forced displacement in those regions. Of course, there is the OAU Convention concerning refugees in Africa. There is the Cartagena Declaration in South America, and other frameworks. The one that we discuss here is a particular one. Actually, there are two. There is a regional body of protection law that stemmed from regional human rights instruments. I am referring, of course, to the European Convention of Human Rights. And then later on, the European Union, which had been established in 57, initially as an organization of economic integration, has come to have a broader and broader remit, and in conjunction with the project of abolishing controls on persons circulating inside of Europe, it has come to acquire competencies in the field of asylum. And so we are now speaking of an integrated regional refugee law and more broadly asylum law, extending beyond the reach of the Geneva Convention. And within EU asylum law, the status of the Geneva Convention as the cornerstone is never revoked into question. It's actually ceaselessly reaffirmed, both in the treaty, in the main policy documents, in legislation. And so one could see the common European asylum system, as it has come to be known, as a powerful regional arm for the universal regime of refugee protection, giving full and inclusive effect to the convention itself, promoting the best practices advocated by UNHCR globally, and complementing the Geneva Convention with a powerful institutional system like a regional court like the ECJ, a powerful monitoring body like the Commission, and also complementing it materially with more robust mechanisms of solidarity and further forms of protection. So this was the expectation when the European Union entered this arena, and in many respects there have been this has been realized, and Anja, Anja Klug, to whom I will give the floor later, will elaborate on this. There was also, however, there is also another aspect to this, which is that regionally in Europe, the Geneva Convention may perhaps appear to be taking a backseat to regional law, meaning that in litigation, in political discourse, there is central place of pride is given to the European Convention of Human Rights. Much is made of the interpretation of EU law, but at least there is very little explicit argument around whether this or that practice is in keeping with the Geneva Convention, whether this or that aspect of EU law fully gives effect to the Geneva Convention. Hence, the question, which is the title of our panel discussion today, whether the emergence of a European refugee law is a blessing or a curse for the 1951 Geneva Convention. The distinguished speakers who have been convened to debate this today with us are Anja Klug from UNHCR, who is organizing the series of events and who has co-organized with me this event, and whom I thank very much, along with all of UNHCR, for all the support. We have Professor Goodwin-Gill, who is a leading authority in all matters of refugee law and who is currently at the University of South Wales in Australia at the Kaldor Center. We have Nicolas from EASO, who will give us a view from the body which is most entrusted in the European Union with the day-to-day implementation of the common European asylum system. We have Julia Zelvenska of ECRE, who is here to give the voice, first of all, of a foremost expert in matters of international and European refugee law, but also the voice of civil society with us. And then I will also take the floor to discuss elements of the Dublin system. My name is Francesco Maiani, and I teach here at the University of Lausanne. So without further ado, I would like to give the floor to Anja Klug for the first statement of this panel. Just to give a last practical indication, we will all take the floor for about 10 minutes, and then it will be an open discussion that I will moderate. To the persons who are connected with us, well, if some of you want to activate their cameras, it will be nicer for us to see whether you are still interested, whether you're yawning, whether you're reading the newspapers. It's always good to have some way to connect to your audience. If we then, we the organizers, see that there is a problem with slow connection, we will be immediately alert you through the chat to perhaps turn off your videos. Thank you very much. Anja, the floor is yours.
Many thanks, Francesco, and a warm welcome to everybody here to this last lecture before the summer break in commemoration of the 70th anniversary of the 1951 convention. We wanted to discuss today a little bit the relationship between international refugee law and regional European refugee law. And the question that Francesco has put in front of us, blessing or curse, I would like to first a quick precision on that question. Maybe we have to better define what are our parameters, and I suggest for the evaluation for the responding to this question, and I suggest that our benchmark is in how far regional refugee law, regional protection standards have enlarged the protection space and the rights for refugees as our benchmark. Francesco has already referred to the fact that we have quite a complex setting here in Europe, because we have, on a regional basis, we do not have a regional refugee law instrument as such, but we do have a human rights instrument with, and we have a standard setting by the Council of Europe with the European Convention on Human Rights as the most important instrument, and the EU process of the harmonization of asylum and also of migration law, of course. I think it's important to point out that these are two very different processes and very different instruments also. The European Convention on Human Rights being a human rights instrument, as we have in many other regions, and the Common European Asylum System, a supranational asylum law, which is much more comparable to national asylum laws than these regional human rights instruments. So I think we have to keep this in mind. Just very quickly on the European Convention on Human Rights, it is as old or a little bit older as the 51 Convention, but nevertheless, it has only been used as protection instruments for refugees as of the 1990s, broadly speaking. And it was because of the restrictive interpretation and asylum practices of European states that basically forced refugee advocates as well as UNHCR to resort to a human rights instrument to find protection to refugees. Meanwhile, the jurisprudence of the European Court of Human Rights on the ECHR has developed a lot, and we have responses that the European Court on Human Rights has given to a lot of different aspects of importance to refugees, and which cover many different aspects. The most important of which, of course, for us is non-refoulement protection under Article 3 and many other aspects, as I've said. In this shortage of time, I just want to highlight 3 successes that that process has had from our perspective as UNHCR. Obviously, the non-refoulement protection of under Article 3 has proven to be quite a forceful instrument, and it has been the basis for the creation of a subsidiary protection mechanism, subsidiary refoulement protection for people who either fell outside of the framework of the 51 Convention as interpreted by European states. In addition, and that's a very positive aspect the jurisprudence of the ECHR has had, it has the interpretation of Article 3, even though a completely different instrument, have also revised some restrictive interpretations of Article 1 and Article 33, the refoulement prohibition under the 51 Convention. And it has also helped to enlarge the scope of the refoulement protection under the 51 Convention, for example, by the jurisprudence on the extraterritorial application of Article 3, which we have used as argument also for arguing for the extraterritorial application of Article 33. There are important advantages the European system has with a court being able to issue binding decisions and the possibility to have interim measures that has obviously strengthened protection for refugees. But on the other hand, there are some risks, because what we see in practice, and Francesco has already referred to it, in practice, adjudicators as well as judges nowadays oftentimes rather refer to Article 3, to the ECHR jurisprudence, than to the 51 Convention. And I see that the knowledge across the legal community on the 51 Convention is diminishing behind the ECHR. Let's turn to the EU, to the Common European Asylum System. Francesco has already mentioned, 51 Convention as the standard for the development of the system is basically in all instruments. So that's obviously very, very, very good. But for me, it's very questionable whether that is more than a solemn declaration, whether it has really been implemented in practice in a way that follows this confirmation of the 51 Convention in the legal instruments. As positive aspects, of course, we have Article 18 of the EU Charter on Human Rights, the right to asylum, that's going beyond the non-refoulement protection of the 51 Convention. That's a progressive development, obviously, but we do not have seen yet that Article 18 has played a very important role in broadening protection space in a positive protection-oriented interpretation of EU instruments. We have a lot of secondary law instruments of relevance. I only want to focus on the Qualification Directive, which is most important for the interpretation of the 51 Convention, of course. And here, again, reference we have to the 51 Convention. We also see that some of the standards that have been incorporated in the Qualification Directive, also picking up on ECHR jurisprudence, of course, have helped to overcome some restrictive interpretations and set some standards in European states law that were, or raised the standards on in some states, in some national asylum laws, and a very progressive, positive development, you know, bringing the non-refoulement protection under Article 3 a step further is the subsidiary protection status created by the qualification directive. And I have to say, especially from Switzerland here, that's a very important development, and we wish that the Swiss would follow that development of the EU. We don't have this here in Switzerland, and we see the difference it has. Challenges, there are, however, a number of challenges. First of all, of course, the qualification directive is a compromise text. It's not only minimum standards, but it's a compromise text. So we see in practice that practices in EU member states still vary greatly, so that there's no. We didn't see yet a lot of harmonization in practice of practices. But what I find more important for our question also is that the text of the qualification directive is a very strange mix of convention text, sometimes changed, and interpretive guidance without clarifying that point. Which of course also gives rise and can give rise to further misinterpretations. Some of this interpretive guidance that the qualification directive has is not in line with international standards. And yeah, it's also not in line with international standards. For now, we have minimum standards, but we have obviously in front of us a proposal to transform the qualification directive into a regulation, which would be then, of course, be even more problematic because some of the negative interpretative guidance in the qualification directive has not been transposed by all member states. There have been high hopes in the European Court of Justice as being able to correct some of these practices. Yes, it has, but to a certain degree, but it has not really yet proven a guardian of international refugee system, but rather a guardian of EU laws and EU principles. And what we see in the few decisions it has issued until now, that it is always referring to the 51 Convention, but it hasn't really used the 51 Convention as a benchmark for its analysis and its decisions. It is also not really using international established rules of interpretation of international law. But I have to say it's really still early times. The court has just started working on asylum issues, so there is obviously always still some possibilities for improvement. I would just like to finish my short first input with a few proposals on how what we see in the EU could be, how we could overcome some challenges. I know that these proposals may not be very realistic, but still I would like to make it because I see the same development sometimes in national law. I think it would really help if an instrument such as the qualification directive would better clarify what is convention text, what is the relation to the convention, maybe stating very clearly that the convention precedes in case of conflict, and clearly indicate what is interpretive guidance. It would also be important and helpful if the EU instruments would better clarify the role, supervisory responsibility of Unhcr under the 51 Convention. There's no mention here in the qualification directive. And obviously outside the qualification directive, it would be helpful. We don't have that possibility in front of the European Court of Human Rights if Unhcr had a formal role in front of the European Court of Justice, such as we have at the European Court of Human Rights, to give life to the 51 Convention in practice in EU law. And I would like to finish my first input by this.
Thank you very much, Anja. This is much appreciated, and coming from the perspective of UNHCR, it's of course very important also the practical ways to move forward and to overcome the challenges that you have identified. I would like now to give the floor to Professor Goodwin-Gill, who will further elaborate on the relation between the two systems.
Thank you, and thank you, Anja, for that very useful introduction. Now, it's not always appreciated just how extensive is UNHCR's involvement in court cases. Under Article 35 of the Convention and Article 2 of the Protocol, of course, UNHCR has been set the task, recognized and expressly accepted by states, of supervising the application of those treaties. And one way in which it does this is by way of intervening, for example, with amicus briefs in ongoing proceedings. Where the law does not allow intervention, then UNHCR can still issue a statement in anticipation of litigation, or more generally issue guidelines on particular issues of interpretation. Now, the 1979 Handbook on Procedures and Criteria for Determining Refugee Status was the first attempt to influence decision-making and was expressly requested by states in the Executive Committee as refugee status determination began to get off the ground. The handbook was drafted in-house with no direct input from states and with no case law. Basically, there was very little case law at the time. The interpretations proposed drew simply on some 25 years of UNHCR experience and interaction with states applying the convention. The text of the handbook, which was reissued in 2019, has never changed. This was largely because UNHCR rapidly saw it would have to pay close attention to what states wanted, to what states thought was the better interpretation, and then it would have to reconcile competing views. Nevertheless, the need for change to take account of a substantially altered international scene was appreciated. Some 20 years later, when UNHCR took up the invitation in the Agenda for Protection to draft guidelines for the assistance of decision makers, whether in refugee status determination or on broader policy questions. Now, UNHCR has a particular standing in international law and in international refugee law in particular. It is a subsidiary organ of the General Assembly and is charged with providing, as we know, international protection to refugees and together with governments seeking permanent solutions to the problem of refugees. The breadth of this mandate should not be underestimated, but arguably it opens the way for UNHCR to take issue with the whole range of refugee responses from initial reception to durable solution. Now, UNHCR is the creature of states, but it is also autonomous, at least so long as funding continues. It cannot achieve or promote the international protection of refugees without a measure of state support, but states are not monolithic. Their interests may pull in different directions. Contrary to those who first drafted its statute in 1950, UNHCR is also a highly operational agency, employing now some 17,000 staff in over 130 countries, a fact that gives it considerable experience in the lives of those in search of refuge. Not everything it does is therefore clearly about protection and about the convention, at least in the narrow sense of requiring it to take a position on the meaning of terms. Ultimately, however, it may be called upon to justify its action or inaction, and for that reason, it must be able to defend itself against the terms of its statute or provisions of its mandate. Now, my focus for the present is on the interpretation of the refugee definition in the context of refugee status determination, RSD, on which UNHCR has issued some 14 sets of guidelines since the early 2000s. They cover a range of matters, such as determining the refugee status of children, the meaning of a particular social group, interpretation of Article 1D with regard to Palestine refugees, exclusion from refugee status, and how to deal with claims relating to religion or military service. Now, evidently, refugee protection is a contested field, and states regularly push back against the demands of protection, especially in regard to what they may claim are novel conceptions of the refugee definition and so-called new groups of refugees. At the RSD level, which nevertheless has significance for wider questions of protection, UNHCR's goal is to achieve interpretations of international legal criteria, the refugee definition, that are consistent with the scope and object and purpose of the Convention and Protocol, and dare one say it, with progressive development as well. UNHCR's focus is therefore on those courts and tribunals, largely in countries that have RSD procedures in place, which are daily responsible for elucidating the meaning of and applying the refugee definition, and deciding whether someone is a refugee or ceased to be a refugee, or should be excluded from protection as a refugee, or should be protected from penalization as a refugee who has entered irregularly. Indeed, I'd go so far as to say that the 1951 Convention is the most heavily litigated treaty in the world today. In its guidelines, UNHCR has employed a methodology that combines interpretation, as it were, from first principles with support from selected case law, drawn from practice in different jurisdictions. The use of case law is instructive because up to now, UNHCR has tended to rely mostly on common law jurisprudence and on the judgments of international courts. Why is that, do you think? Well, leaving aside the linguistic challenges, it's because common law and international courts tend to adopt what I call a narrative approach to case analysis, reasoning from the facts here to the facts there, and attempting to lay down and to illustrate the general issues. For example, showing that membership of a terrorist organization is not alone sufficient to justify exclusion, and why evidence of knowing participation is required. Obviously, this selectivity may give rise to an appearance of bias. Times are changing, however, and courts in other jurisdictions, once ready to decide refugee cases on the basis of an exercise in syllogistic logic, are now beginning openly to wrestle with the facts of the case before pronouncing their conclusion. In France, the Cour nationale du droit d'asile is a case in point. And it's likely that future guidelines will incorporate a wider, more balanced perspective of the changing jurisprudence. But more balanced, in what sense more balanced? A balance of numbers is not likely to be of much use to the refugee or their lawyer, knowing that 14 states interpret particular social group to include immutable characteristics and social perception, while 15 states consider one or the other as controlling, brings little comfort. For that reason alone, case law is inadequate. And what UNHCR must do, if it is to be able to provide international protection in a dynamic environment, is to analyze and assess the jurisprudence, and then to advance an interpretation that is best able to capture the sense of the refugee definition, that progressively develops the law understood in light of the Convention's object and purpose. Frankly, UNHCR's relations with courts are somewhat dysfunctional, it seems to me. It does not act like a treaty supervisory mechanism, pronouncing ex cathedra on the issues of interpretation. Many tribunals still seem to go out of their way to stress that what UNHCR says is not binding, and then to ignore it. This tends to happen more often with the lower courts, but in any event, UNHCR's positions on interpretation deserve greater respect, and courts ought to follow them unless they can produce cogent reasons for not doing so. Now, UNHCR, whether it's drafting an amicus brief or general guidelines, will need to be in touch with the grassroots, with protection issues as they emerge and as they are fought in court. It ought also to see national courts as, to some extent, partners in a common endeavour. The courts are agents of the state, and as such, agents for the development of the law. They are a natural point of intervention, a place where UNHCR can facilitate and enable the adoption of interpretations of key criteria to promote the broad agenda of international protection. And judicial decisions may build in time to reflect a consensus among states, a binding customary international law on meaning. And in Europe, how has UNHCR's task of supervising the Convention worked out in Europe? At first glance, as Anja has mentioned, things may look good, with the Convention and Protocol recognized as underlying European law and policy, and UNHCR recognized as a key partner. It's repeated many times. From another perspective, however, things do not look so good. Border incidents involving the abuse and ill treatment of asylum seekers, criminalization of refugees and of rescuers and others trying to save lives to ensure that states fulfill their international obligations, pushbacks and pullbacks, and indefinite detention in abysmal conditions are, it seems, the order of the day. On the one hand is the failure to achieve a common European asylum system. On the other hand, illegal, although widely tolerated, abuse of executive power. With regard to the first, it's not clear to me what further legal influence UNHCR can exercise to promote consistent interpretation and application of refugee criteria. procedural guarantees, or reception conditions. There is, for example, a considerable protection gap between the recognition rates in different countries, which is an obvious reason for secondary movement. There are also inconsistencies between the international status of the refugee as defined in the Convention and the European status of the refugee. There's a danger too that differences will become concretized or set in stone, left behind as international refugee law moves on. Now, in fact, the availability of alternative protection mechanisms offers some hope that this will not happen. And the European Court of Human Rights, for example, which is also open to UNHCR's views, may help to keep Europe in line with international protection. Perhaps the next steps in European integration will provide some answers. Perhaps a European Asylum Agency competent to determine claims for protection and a single European refugee status which entitles those recognized to enjoy convention rights Europe-wide. This, should ever happen, should ever come about, will necessitate doing away with Dublin and its related bureaucratic industry and recognizing that protection finally is a European responsibility. Obviously, it would also entail substantial changes in the current mindset over solidarity and sovereignty. On the second problem, the illegal action on the borders and beyond, this will not be solved in the courts, or promptly anyway, by a change in policy and political will. These issues too will require a change in mindset. Governments must do what they show no inclination to do, send a clear message that abuse will not be tolerated, and back it up with sanctions. Thank you.
Thank you very much, Professor Goodwin-Gill, for this very rich input for our discussion. I'm sure that there will be many threads that we will be want to taking up in the follow-up. I will resist the temptation to call on Nicolas Jacob to comment immediately on the prospect of a EU agency determining claims, but I may not refrain from this later on in the discussion, but rather I will give him the floor for his statement, because Nicolas Jacob comes to us from EASO. He's been working in the common European asylum system for a long time now, in a body that is specifically entrusted with, overseeing, facilitating the implementation, supporting the implementation of the common European asylum system. And I'm extremely curious to hear his views on the relations between this common European asylum system and the universal refugee protection regime of the Geneva Convention. Mr. Jacob, the floor is yours.
Thank you, Francesco, and thanks again for the invite, of course, today. Well, just my aim is basically to tackle 2 points. First, I propose to take a quick look in the rear view mirror that highlight the difference, between the legal instruments that form the basis, respectively, of European refugee law and of international refugee law. And then secondly, I would like also to have a look to the foreseeable future of the common European asylum system, and more especially to what extent the new Pact on Asylum and Migration, which is now on the table, could change. And I will do that with a focus on the regulation on the European Union Asylum Agency, because I would like to reassure you immediately, I'm not going to describe the whole content of the new Pact. When we look at the 2 types of legal framework, the 51 Convention and its protocols, well, I mean, they can be portrayed as having a quite static character. Whereas the common European asylum system, in return, presents a much more dynamic one. And this over, of course, I mean, the last 20 years. So what I want to underline is, of course, that let's say to set the stage, that, of course, just the origin of the 2, let's say, legal frameworks are very different. And if I wanted to tackle that, is like, are these differences, I mean, can they explain somehow that some tensions can arise today between the 2 regimes? So, as we know, the 51 Convention has been adopted in the aftermath of the Second World War, essentially to deal with the resulting massive population displacements, whereas the CEAS was born out of the recognition that in an area without internal frontiers, asylum needed harmonized regulation at the EU level. It's very pragmatic, let's say. It was considered that a failure to do so would likely result in the secondary movement of asylum seekers. And this was the starting point. And the Amsterdam Treaty then not only provided the legal basis for the creation of the system, but also clarified the legal foundations of such a common system. Again, you know, the 99 temporary conclusion, the first to revert to use this term of CEAS. And from its inception, in the conclusions of temporary, the Council clearly stated that this system would be based on the full and inclusive application of the Refugee Convention. I think we already underlined the fact that, you know, it has been said repeatedly, it is written somehow a bit everywhere. However, the scope of the Common European Asylum System was also to be wider than the Refugee Convention and its protocols, insofar as the CEAS would not be limited to laying down criteria for qualification for refugee status and the benefits attached thereto. Instead, the aim was to establish a system which would regulate all facets of asylum. The CEAS from the beginning was to include, I mean, in the short term, a clear and workable determination of the state responsible for the examination of the application, common standards for fair and efficient asylum procedure, and also, very importantly, common minimum conditions for the reception of the asylum seekers. And then I would say somehow, thirdly, the laying down of rules on the recognition and content of the refugee status. So, in other words, the CEAS primarily sought and continues to do so to date to harmonize national asylum procedures. That's the main target. And this said, as already recalled, the Refugee Convention will always occupy a central place in the designing and implementation of the common policy on asylum. And as we know, it's by virtue of the explicit reference made by EU primary law to the convention itself. And of course, all secondary EU legislation explicitly reaffirms the fact that the Refugee Convention is the cornerstone of the CEAS. Just to mention it, because I don't want to, I mean, my aim is not to talk here really about case law, but because that's also an aspect, a very important aspect, that the Court of Justice itself recalled in several occasions that the EU asylum acquis must be interpreted in conformity with the Geneva Convention. Just only to quote one case, I mean, it's the famous Abdullah case of 2010. Well, so if there are tensions, I do not think that we need to look for them in the quite radically different historical backgrounds and the different nature of the respective legal frameworks. Nor is it because of the lack of common legislation in Europe, but well, the dire need to keep thriving for the common implementation of the existing rules, which entails an agreement between all member states on a common policy, a common approach, which, as we know, is still not really there. And if the EU is widely recognized as a key global player in the field of asylum, well, we are still along the very long road to a truly common and effective European asylum system. So basically, the CS remains a work in progress. And on this note, we must not lose sight of the fact that if this year we are celebrating the 70-year anniversary of the 51 Convention, well, the CS only has just over 20. And to conclude on this, if tensions may arise between the international and the European regimes, and just because it's just to repeat what I say, it's really due to the lack of a genuine harmonized implementation across of the different of the CS across the EU. Okay, so you know, like having a fully, truly common approach, a full implementation of the CS. I mean, you know, every article you read, you can find this kind of sentence. It can then be perceived as a sort of fata morgana. But what I would like to stress is that the implementation design of the EU asylum policy has slowly but surely started to shift. And this brings me to my second point. Last September, I mean, the Commission presented the new Pact on Migration and Asylum with the aim to cover all the different elements needed for a comprehensive European approach to migration. And let's note that the engagement of the EU in migration with international partners at bilateral, regional, multilateral levels is one of the key pillars of the Pact. Now, I would like to quickly focus on the fate of one of the proposals, actually on the table since 2016, nothing really new there. It's the regulation for an European Union Agency for Asylum, EUAA. Why? Not because I'm working for EASO, but, or maybe still a bit, but no, it's because, as you may have heard, this regulation may be adopted in a very close future, whereas the other proposals only at a later stage. So, as much as it would be very hard to imagine the Refugee Convention without the UNHCR, it is difficult to imagine the future evolution of the CS without the EUAA. The EUAA can soon become a tangible example of European solidarity, and it must be able to meet the level of ambition needed for the EU to have this efficient and effective common European asylum system. And the agency can become then, at the European level, the center of expertise on asylum, and really have a mandate that will allow to facilitate and improve the functioning of the system by coordinating and strengthening further this practical cooperation and information exchange on asylum among member states. The EASO and tomorrow the European Union on Asylum, the Asylum Agency, we don't have a supervisory role like the UNHCR. That's not our mission, basically. Just to conclude, with the new mandate, the aim is really to allow the Agency for Asylum to provide full operational support to the member states where needed and reinforce their capacity to manage the caseload at all levels. Because at the end of the day, ultimately, you know, we are pursuing the same goal, ensuring effective international protections to refugees. Thank you.
Thank you. Thank you very much for your intervention, which of course opens vistas that I hope we will be able to discuss in full in the second part of our event. But before we get there, I would like to give the floor to Julia Zelvenska, who will more directly address this point that has been evoked several times already of how the European Court of Justice has tackled this coexistence of the common European asylum system and EU law in refugee matters and of the Geneva Convention. Please, Julia.
Thanks a lot, Francesco, and thanks a lot to everyone else for your thought-provoking remarks. So I think I agree with a lot of them, and specifically what I would like to do, I would also like to kind of focus on some of the remarks that you mentioned, that what actually happens in law and what happens in practice is not quite the same thing. So basically, what I wanted to focus today is whether EU and domestic court jurisprudence across Europe is a blessing or curse for international refugee law regime, and whether such jurisprudence has a wider outcome impact on the wider jurisprudence outside European Union and also outside Europe. And basically, whether we still think that following the jurisprudential developments, we can call the Geneva Convention a cornerstone of the regime in European asylum law. And what I'm going to, of course, it's quite impossible to analyze all the jurisprudence, I mean, domestic jurisprudence and CJEU jurisprudence, that it will be mostly some of the empirical basically observations from the case law that we see, and of course also some of the experiences that we had through the ELADA network, which is the network of the asylum lawyers who is trying to litigate also some of the cases. And what I wanted to start with is actually just to reiterate what already has been said, that under the convention there is only a supranational settlement mechanism, which to my knowledge has never been invoked, but the individual state, the disputes between the individuals and the states are actually decided by the domestic courts, and there is no supranational avenue that can decide on these disputes. And in the European Union, of course, the domestic courts, as far as the EU asylum law issues are concerned, have a benefit of turning to the CJEU for some guidance on how to interpret the specific provisions of EU law. So this is why the jurisprudential developments are so crucial for the development of the EU and international asylum law, because I think it has quite an impact, as I mentioned, both in Europe and beyond. And also something that I wanted to highlight here, it would be a dual role of the domestic judges in the European Union member states. So firstly, and based on the settled CJEU case law, they would be primary actors ensuring the correct implementation of EU law. But they will also need to ensure the compliance with the international treaty obligations, including the obligation under the Geneva Convention. And sometimes these two roles wouldn't be in harmony. Sometimes they will be conflicting depending on the standards under the international law and EU law. And of course also on the CJEU take on some of these issues. And of course, even though that in theory, like we all understand that the international law would be taking precedence, in practice is quite not the same. And specifically now, for example, I think that a lot of domestic judges and lawyers, the international refugee law is completely outside of their comfort zone. And if they actually think of the Geneva Convention, they would essentially be thinking of two articles, Article 1 and Article 33. And this is already an issue that that has to be remedied by a number of efforts from various sectors, including ECHR. And basically, when I was talking about the prominent role and the guiding role of the CJEU, what I wanted to mention is I wanted to quote the Advocate General Hogan, who issued an opinion in one of the interesting cases this year, which was the last preliminary references from the UK, the case in OA. And what he highlighted in his opinion, he did highlight that the Geneva Convention is a cornerstone of the international legal regime, and that the Qualification Directive was adopted in order to guide the competent authorities in the application of the Geneva Convention on the basis of common concepts and criteria. But he also said that where the text of the Qualification Directive departs from the language of the Geneva Convention, these provisions of the directive should be interpreted as closely as possible with the underlying objectives of the Geneva Convention, also given its role in the TFEU and the Charter, which in turn implies that the Union legislator intended that any legislative measures such as Qualification Directive must conform as nearly as possible with both the letter and the spirit of EU law. So for me, it's actually summarizes the take that the CGU takes on the international refugee law and UNHCR guidance, because there have been, and I'm not going to talk about numerous instruments of the CS, but I would like to give some examples related to the Qualification Directive. So of course you have quite mixed feelings after the CGU judgments, because in one way it endorses and makes sure that protection under the international law is asserted, but on the other hand, like it also sometimes take away some of the protection that is highlighted and is guided by UNHCR. So I would, if we're again turning back, whether it's a curse or a blessing, for me it's perhaps a mutually stimulating relationship, because it also sometimes pushes the UNHCR also to adopt some of the doctrinal take on some of the issues on some of the issues relating to the refugee law, but it's definitely not necessarily a nurturing one. So here it's sometimes a blessing may become a curse, and a curse can become a blessing. So it's kind of twofold as far as I'm concerned. And just again, as I promised, just to give you an examples, and I think of a number of cases which I won't be able to describe right now, but I'm happy to talk to them later. And I'm thinking of the cases related to cessation, related to exclusion and Article 1D, and I'm also thinking of cases that relate to particular social group. So I would like to maybe just focus on XYZ case, which actually illustrates some of the points that I mentioned, that the curse may become a blessing and the blessing may become a curse. So basically, essentially, the case related to the fact whether the LGBTI asylum applicant could be considered a member of a particular social group, whether they can be required to conceal their sexual orientation, and whether criminalization per se can be also considered. And of course, when you look, and there's been also an intervention by UNHCR, so that was also the role that was highlighted by Professor Goodwin-Gill. And when you look at the outcomes of this case, of course, for specifically the impact of this case outside Europe, of course, for the countries outside Europe who are still hesitant on whether the LGBTI applicants can become members of a particular social group, is quite a positive impact. But in the same way, the way that the CGU dealt with basically application of the social perception and characteristic tests, which was for UNHCR, these are two alternative approaches, while the court decided that under the EU law, they should be cumulative. So it's something that would have impact on a lot of other countries. But at the same time, if we are talking about concealment, that is definitely, there have been quite a great impact where the court actually reiterated the position of UNHCR that someone cannot be expected to conceal and hide their orientation. But if we are looking at the criminalization per se, it actually went completely in the opposite direction, well, not completely, but in the opposite direction to the UNHCR position, and it focused on how, on the sanctions and basically how the law would be applicable rather than on whether there is a specific legislation in place that can discriminate and create specific hardship for the applicants. So when you actually try to argue the similar cases after this judgment, and we try to do so before the ECHR, basically this judgment kind of limits your attempts quite significantly, and it also sees how it actually undermines the international refugee law. Basically turning back to some of the issues flagged in Francesco from the very beginning about what the courts have done or haven't done to the international law and UNHCR guidance, I would just want to finish with what the court shouldn't do to the UNHCR guidance. And actually I think that the court shouldn't comment on the UNHCR guidance, and I think there have been quite some interesting basically reiteration by the Advocate General Tanchev in one of the cases, which actually questions the consistency of UNHCR guidance. Likely it wasn't picked up by the court, but this is something that definitely undermines the guidance and international refugee law. So it would be actually good if the court wouldn't actually go that way. And just to conclude, of course, like nowadays, a lot of regional courts, and CGU is not an exception, they actually reiterate the autonomy of the law that, like within the framework of which they function. And again, if we're talking about the CGU, it's not only about the CGU, and I think the CGU is actually trying to find the balance between the convention and EU law. But again, if we're talking about some of the cases that were decided earlier this year, there was also a case which related to the additional exclusion clauses that was introduced into the qualification directive, and whether it would be against the exhaustive list under the Geneva Convention, which is case XXMM, which is quite telling in this case that in the submissions of the party, while the European Council, the European Commission, and some of the member states, they highlighted that the EU asylum law should be interpreted in line with the convention. The European Parliament, when it was commenting on the jurisdiction of the court, actually said that the directive should be interpreted as an autonomous legal act because the EU law is autonomous law, and it should be interpreted not in line with the Geneva Convention, but rather TFEU and the Charter. So we just like to flag that there are quite a lot of challenges there, but I think the most upsetting is what I mentioned in the very beginning, that now the international refugee law isn't a comfort zone, and I think it's good to have such a discussion. So maybe it will, maybe it will change some of the views in that regard.
Thank you very much, Julia, for your statement. And now I enter into very uneasy territory, because defying every possible concept of conflict of interest, I'm going to give myself the floor and monitor that I respect the time. So it will be a difficult task to be two at the same time, the organizer and the speaker, but I will try to discharge both duties honorably, let's say. So what I wanted to talk about is Dublin and its whole industry. I guess that I am part of the industry in the sense that I've been commenting on the Dublin system since 2003, but the Dublin industry that Professor Goodwin-Gill referred to is a very complex thing. It includes national bureaucracies, it includes supranational administrations, it includes smugglers even who take advantage from the Dublin system by making business on people who want to move from one part of the other to Europe while being formally prohibited from doing this. And all of this revolves around the legal system that we have had in operation since the mid-90s, so that we know very well in operation, even though it has been transforming and morphing all over the time, from the Schengen Convention to the Dublin Convention to the Dublin II regulation to the current Dublin III regulation. And the relation between this body of law and the Geneva Convention is a complicated one. Well, I would start from one point that Julia made, and I think that it encapsulates well the whole purpose of the talk that we have. Refugee law is out of the comfort zone of too many of the persons who work on the common European asylum system. And I would relate particularly my experience. I was in a working group with people drawn from Dublin units from several member states. And when I first mentioned the Geneva Convention as relevant to their work, their attitude was like, no, it's not. This is not refugee law. We are dealing with the Dublin system. It's got nothing to do with refugee law and refugee rights. We just have to put those people in the right member state and do it as fast as we can. And they failed to see the connection that there is, which is a deep one, between the operation of the Dublin system and the realization of refugee rights. So there is an awareness element here that is really crucial, both for European law at large and for the Dublin Convention, the Dublin system, sorry, more in particular. And in the connections that I see and that I would like to highlight are two. One is on a conceptual level. In a way, the Dublin system is the descendant of an initiative of UNHCR, which was taken to fill a gap in the convention. Famously, the convention gives a set of rights to anybody who becomes a refugee the moment that that person crosses an international border and fulfills those rights. But the Geneva Convention does not include any rules as to which state should extend its protection to refugees. And so in the 70s, we've come to know a phenomenon that was somewhat cynically called refugees in orbit. Refugees in orbit, meaning refugees who try to access protection in one state and are constantly referred to another state. Well, you cross that state is safe, you can seek protection there. So we don't examine your application. And once those people were sent there, they would be confronted exactly to a mirror image claim that they came from another safe state. So UNHCR took the initiative, or more exactly, it was the executive committee, to lay down some principles and to recommend the adoption of a system that would ensure that every refugee would find an asylum country, as it was called in those conclusions. And the Dublin system can be seen as a very much later realization on a regional level of that idea. So in that sense, you may say that it furthers the goal of the Geneva Convention because it complements it there where there is a vulnerability. But at the same time, it is really deviating from the Geneva Convention in terms of not only the principle of allocation that it lays down, but I would say the core preoccupations that underlie it. The Dublin system is very much given a common goal of affording access to status determination to everybody who comes look for protection in Europe, which is the most commendable part of the Dublin system. There is a strong preoccupation with linking that to migration management and to, encouraging member states to maintain very restrictive policies at the border, etc., and less of a preoccupation, which is the core preoccupation of the Geneva Convention of affording durable solutions, meaning allocating refugees to the state that would be best placed to extend the best protection in the long run to that particular person. And also there is a very strong discrepancy between the system realized in the Dublin system and what UNHCR proposed in terms of the ethos of responsibility allocation. Whereas UNHCR at the time said allocation should happen in a way that allows refugees to express their wishes as to where they would like to rebuild their lives, which is something I think we can all connect on some level. The fact that if you have been uprooted from your life, you should have at least a measure of control on where you are supposed to rebuild your life. The Dublin system, due to fears of various kinds of abuses and asylum shopping, is permeated by a very rigid taboo that refugees are not to choose where they will go and request and obtain protection. And I could go on for several hours, not minutes, about how all of this does a deep disservice to the operation of the Dublin system, but I leave it there just to point out that there is this uneasy relation between the two. And of course, much of this uneasy relation could be vindicated at the level of the application. If you read the preamble to the Dublin III regulation, c'est le paradis des droits de l'homme. It's the paradise of human rights. You know, you read the preamble of the Dublin III regulation and you think, this is the system that will afford comprehensive protection to families, that will place the needs of children at the center of the whole determination, that will give refugees humanitarian support where they need it, et cetera, et cetera. And you could say that the Dublin system, and as a lawyer, I would really argue that the Dublin system affords all sorts of flexibility to accommodate any human rights-based claim and any claim based on the Refugee Convention. But reality has been so far quite different from this. I will not rehearse all the woes of the Dublin system because that would take us too long. Let me go back to our point, which is the relation to the Geneva Convention. First of all, where is the friction problem? Where is the friction point? If we were to take the founding texts of the Common European Asylum System at face value, there would be no problem from the standpoint of the Geneva Convention, because all the member states would be respecting regional standards that incorporate a full and comprehensive application of the Geneva Convention. Hence, you know, there can always be unfortunate accidents, but in the main, allocation would be neutral in terms of the protection prospects of refugees. As we all know, this is not the case. And today, despite decades now of work and significant progress, I would like to stress it, because we all too often tend to say, oh, standards still diverge, as if nothing had been done. No, much has been done, but standards across Europe still diverge to an extent that in some member states, they do not meet the minimum of the Geneva Convention. And this issue has been completely overshadowed in the abundant litigation on the Dublin system. There is very abundant litigation on the Dublin system, and one of the core topics is, will the responsible state be safe for this person? And you could expect the Geneva Convention to be a part of that litigation. You know, litigation on whether the person, on being transferred to the responsible state, will receive the full extent of the rights that are recognized to him or to her by the Geneva Convention or by its EU counterparts. There is a mysterious Article 18 in the Charter of Fundamental Rights, which refers to the right to asylum in conformity with the Geneva Convention. And we all know that the Geneva Convention rights are recast in the EU legislation. So who cares about formalities? Maybe we don't have a discussion about the Geneva Convention. It would be all the same if we at least had a full discussion on the EU counterparts to the Geneva Convention. But if you look at the case law, both at the national level, at the ECHR level, where it is most natural, and at the ECJ level, the whole issue has been swallowed up by Article 3 of the ECHR and Article 4 of the Charter, as if those were the only standards by which you are to judge on the permissibility of a transfer. So as if the only question were, is this person going to be treated in a manner that is inhuman or degrading? Now, of course, this is the way that courts, regional courts have approached the issue. And the fact that the issue of whether refugees are to enjoy the full extent of Geneva Convention rights has been swept out or under the carpet reflects different sets of priorities. I mean, the European Court of Human Rights cannot be criticized for focusing on Article 3 ECHR because that is formally its remit. that court doesn't have the task of interpreting and applying the Geneva Convention. The ECJ, one could have expected to take a more expansive view. But the point is that its own case law is very much permeated by goals and logics that are own to EU law, but are somehow foreign to Geneva, to the Geneva Convention and refugee law. Effet utile, mutual trust, the ever-present issue of whether the case will enhance or detract from the application of EU law. So there is a clash of logics there at work in the implementation of the EU asylum acquis that is somehow impeding the Geneva Convention from taking the center stage place that is assigned to it by the founding texts of the EU. And rather than finishing on a bleak note like this, I will abuse my time and take 30 seconds more to point out that it doesn't necessarily have to be so. Meaning that you could conceivably construe EU law, which is based on the Geneva Convention, not just on Article 3, as a system, as something that is coherent, within which transferring a person from an area to the other of that common European asylum system presupposes that there is no evidence that the rights bestowed on that person by the Geneva Convention and EU law, as implementing Geneva Convention, will be respected. It could be a feasible construction in terms of legal interpretation of the common European asylum system. Of course, it is nearly unthinkable that the European Court of Justice will tomorrow take a judgment that says, I reverse my previous case law and I say that Dublin transfers are premised on full respect for the whole range of the Geneva Convention rights. Why is that so? Because if the Geneva Convention decided that, then a great many Dublin transfers would be revoked into questions. And we know that the European Court of Justice has a very powerful preoccupation with the effet utile and effectiveness of mutual trust and of the Dublin system. So probably the only way to get there is by building on the ground this compliance so that the step does not become too high for the court to cross of its own motion. And so that we realize on the grounds through administrative action, through lobbying, through the role of academia, civil societies, and the administrations involved, including at the European level, the idea, bottom up, step by step, that transfers in the Dublin system are unthinkable unless the full range of Geneva Convention rights are ensured at the other end of the transfer. And I'll stop here, having passed by a couple of minutes my allotted time, for which I, of course, apologize. So we have all taken our initial statements, and I would like to open the floor. We still have a full 3/4 hours, and I thank all the speakers for their discipline, which was apparently greater than mine in respecting the times that we had decided. So let me open the floor to any questions, including from the speakers themselves. Raise a hand and I will take a look and give you the floor. Okay, I will launch the discussion myself as I don't see many coming up. And it's something that happened before while Julia was speaking and quoting Advocate General Hogan on the fact that EU asylum law has to be interpreted as nearly as possible close to the Geneva Convention. And I wanted to elicit a comment from specifically Anja. Sorry, Anja, for pulling you from the jacket into the fray, because I saw you like taking expressions when you heard this. And I wanted to hear from you what went through your mind when as Julia was saying, as nearly as possible.
Thank you, Francesco. Yes, I have to say, even in the virtual space, you can see body languages. And I think it really very well shows the problem we have. Because, you know, I would have argued if the case were in front of me, of Unhcr, it has to be in line with the 51 Convention, not as nearly as possible, because it shows the priorities the advocate and also the court obviously are having, and that they are different from the priorities that we would have as international refugee lawyers. And I think it's a very, because I've come across this sentence before, but Julia putting it in front of us, I think it's it shows very importantly the problem we have. And since I have the floor, I would like also to use it to get a little bit of energy into our discussion and challenge what I think I heard Nicolas saying, namely that this is all a question of implementation, that the challenges we see, the difficulties we see will be all solved very soon by the new EASO. Sorry, I have to still learn the new name. Once you have the full power, this will all be solved. I would like to challenge this statement. For me, the challenges we see and the problems we see in not respecting international standards are not simply a question of non-implementation. That's certainly part of it, but there are some structural issues, and I think they came very clearly across in the presentations of the other speakers, where we have the structural issues. And I think even if everybody applied the system, the laws as they are, we would still see that we do have some problems with regard to its relationship to the 51 Convention. And for me, as I said, for me, it's very important what I said in the beginning, that the benchmark is not, let's follow the text of the 51 Convention. The 51 Convention is minimum standard. We would be all very happy, of course, seeing that protection provided in the regional space goes beyond the protection provided by the 51 Convention. And we see it in certain areas, of course, like the subsidiary protection and some others. But the problem is that what we see in some areas in Europe is that protection is falling behind international standards. And that's where we come in and we have to raise concerns.
Thank you very much, Anja. I would like to give the floor immediately to Nicolas so he can respond. And then, of course, I again encourage everyone to ask questions. The way to do it is very easy. Down on your panel, you have something called reactions or something like this, and you can raise your hand as I just did, like this. And then at that point, you will pop up on my screen and I will give you the floor. Sorry, Nicolas, for this.
No, thank you, Francesco, and thank you, Anja, for the question, because just to make sure also about my point, I'm not there to pretend, of course, that because there will be a EUAA or just that there will be legislative reforms that all problems will vanish, or even if we go further into this common approach regarding the very implementation of the existing rules. I mean, somehow finally, if the just the second package of the CEAS was really fully implemented, would be already in a better position today. So, and this said, it's just that's for sure. It's true. And we know, I'm sure, both what are most structural problems. Also, the new, just only to pick up one of them. Well, the new AMR. Regulation, which is there, poised to replace the Dublin one. Of course, we know also the border procedure, the revised proposal regarding APR. Of course, there are lots of comments to be made there. So just to clarify that very clearly, though, just also, yeah, I'm also giving my input from just EASO. Also, EASO has not been designed to be an operational agency, basically, in 2010. They were, just, like the basis is there to organize all what happened on the ground, led EASO to become more and more an operational agency. That's very obvious. basically. And so some also like to fulfill and to, just to act in some circumstances. I mean, I don't want, it's not like the UNHCR, but just, also, doing tasks that were probably not foreseen by the drafters of the EASO regulation. So, just, just especially, I mean, just in Greece, Italy, for instance. So, this said, I mean, basically, just Anja needs to say that, just we are on the same page.
Thank you. Thank you very much. I will give the floor to Fabienne Baxevanos from UNHCR, who is connected with us and who raised a finger and asked to take the floor. Fabienne, the floor is yours.
Thank you very much, and sorry for my technical inability to raise my hand. Thanks for giving me the floor. I'd like to come back to what Anja and also Mr. Goodwin-Gill and Julia talked about, UNHCR's court interventions. We're doing that here from Brussels, and I would like to make a comment on two things. One, the CGU's relationship with our court interventions, and then second, UNHCR as a party before the CGU. On the first, I really agree with what Julia has described as a mutually stimulating relationship. We actually did an impact assessment of all of our court interventions, not only before the CGU, but also before the ECTHR and before national courts. And interestingly, and we did that since the 80s, since our first intervention since the 80s. And interestingly, it was before the CGU where we had the highest impact, according to how we defined it. So the CGU, out of all of these courts, is by far the most aligned with our interventions. So where we intervened, the CGU has actually, by and large, found in the same vein as UNHCR, which of course is really encouraging. And it's also clear that the court reads our statement and reads not only our court interventions, but also our policy papers, our comments on the Common European Asylum System. There were a couple of procedural cases in recent years where the court, or at least the AG, referred to our APR comments, so the comments on the proposed asylum procedures regulation. So I find that really encouraging. And the court also in standing jurisprudence not only says that the 1951 Convention is the cornerstone of international, also of the international refugee regime, and therefore also for EU law, but also that the documents that UNHCR issues are particularly relevant. And it said that recently in the Hagbin case. So that's very encouraging. When it comes to a party, it's true what Mr. Goodwin-Gill said, we don't have standing as such before the CGU, but the reason is easy. The CGU does not join parties. The CGU takes the parties that travel with the national case up to Luxembourg. So it's not up to the CGU to add new experts. It's really the CGU takes the parties before the national court. We just had an event with CGU Judge Bay Larson on Friday, and he explained that again, that this is just a CGU. That's a typical feature of the preliminary reference procedure, but he encouraged, in this case, the national judges that joined that call to join UNHCR at the national level, because then in this case, we can also appear as a formal party in Luxembourg, which of course is then forcing the CGU to take us into consideration. And if this is not the case, as was also mentioned, we can still do public statements as we do relatively frequently. And we know that they're also taken into account, and there may be also a plea to the academics on the call today. They're all public, they're all on our website. So if you want to know what we've said, legally speaking, on, for example, the SSV Italy case, or the latest pushback cases, pullback cases, cessation, Palestinian issues, our interventions are all there. So if you like them, refer to them, and perhaps by that way we can also broaden the voice that we're issuing there. Thank you.
Thank you very much. I will let Anja and Professor Goodwin-Gill comment on this. But before I do, Julia, is your comment somehow related to this, or is it completely different? Completely different. Okay, then may I perhaps add a little consideration to what Fabienne Baxevanos just pointed out, which is we may perhaps ask ourselves, what do we mean by the Geneva Convention of 51? Because of course, we're not just meaning the articles of the convention. We mean more by this. We mean a number of interpretive practices that go around it from UNHCR, and not only there, because as Professor Goodwin-Gill pointed out before, there is kind of an interpretive community around the 1951 convention. And this, I think, is where things are a little bit less positive in terms of how the ECJ handled the Geneva Convention, because I am aware, of course, of the times that the ECJ said that it would give some authority to UNHCR documents. I'm also aware of the cases where the ECJ just went straight the other way without giving it a second thought and not even engaging. And that's kind of the problem. I mean, we are used in refugee law to the idea that courts are engaging together. You have the courts in New Zealand who are engaging with what the UK House of Lords said at the time, or the UK Supreme Court said more recently. And they are also referencing something from Australia, who are also referencing something from Canada. It's true, mostly common law. Huh? The continental traditions are a little absent, even though not always. I mean, Swiss judges, when they refer to refugee law, they may take cases that we agree with, other we don't. I won't let Anja start on this, but they tend to cross-refer to other things, whereas the ECJ tends to say EU law is like this, and A, B, C, the effet utile of EU law, and I conclude that then this is the conclusion. It's part of the judicial style, of course, but part of the problem seems to be that they don't systematically engage. Of course, it's very positive that they take into account the documents, whether in conclusions or in the judgments. So I just wanted to add something to what Fabian Baxevanos said and push it on to Anja and Goodwin-Gill. May I just remind myself that if we are to make the best use of the remaining half an hour, let's try to be progressively more brief and have a nice ping pong of questions. And Julia, I did not forget your question. It's coming up. But first of all, perhaps Anja and Goodwin-Gill, who were directly addressed by Fabiane Baxevanos.
No, I think Fabian's intervention shows that my point that we have to let the court also evolve, or the relationship with the court evolve, is a relevant one. I'm very happy to hear that, you know, that because I was there when we first met the court, which is 10, 12 years ago, that it has made quite a way. I still think that, I mean, I have to say, I think the court could be bolder in its analysis and in its use of both the 51 Convention as well as of Article 18. So, which is of course not contradicting to what Fabian said. And I also have to thank you, Fabian, because I think it's important that we are not focusing on what the court doesn't do right now, but more how we can use the space available there in a better way to further evolve this relationship, and also to come to decisions that help us to enlarge the protection space where it's not yet there.
Thank you. Professor Goodwin-Gill, do you want to append a comment to what's been said?
Well, I want to comment, but I also want to raise a question in particular. I understand that the convention is to be, or the European system is to be interpreted consistently with the convention, but how do you argue for an interpretation in relation to provisions that are not in the convention on revocation of refugee status? There's no provision in the convention which permits revocation of refugee status, for example. Yet there are plenty of examples in the qualification directive of the circumstances in which the state can revoke refugee status. How do you deal with that? For the perspective of consistent interpretation.
My first blush response would be that you deal with that precisely in the way that refugee lawyers have dealt with similar provisions in national law, by taking care that the implementation of those provisions does not overstep on rights that are bestowed on refugees. And here, I mean, the case law on the exclusion clauses is interesting in this respect, because there is this fine distinction, which is at first blush, very formalistic, but still quite important between what a refugee is under EU law, meaning a person who has been recognized as a refugee, and what a refugee is under the Geneva Convention, meaning somebody.
That's what I was referring to when I talked about a European refugee status, a European refugee. It is quite different in many respects from a convention refugee.
Yes, exactly. And somehow seeing those exclusion clauses as regulating access to the European refugee status without prejudice to the universal refugee status, unless the conditions of Article 1D of the Refugee Conventions are fulfilled. It's delicate, of course.
And then I have several reservations about an initiative which was pioneered by Advocate General Sharpston, I think, in relation to Palestinians, who has basically persuaded the court to accept the introduction of a procedure for determination of whether Palestinians are or not ipso facto within the terms of the convention. I wonder about that. Palestinians are now required to go through effectively a refugee status determination procedure, whereas the objective of Article 1D was precisely to mean that they should not have to do that.
Sure. That is exactly the case that I was referencing when I say the court went straight the other way, and I find it actually very regrettable that decision was taken. I wanted to give the floor to Julia, who asked it of me quite a few minutes ago. So sorry, Julia, for the delayed response, but I wanted to let the discussion take on its own dynamics.
No, it was quite an interesting discussion. Thanks. Like, I also obviously meant the exclusion case, but I didn't want to go into it because I don't think that 10 minutes is enough to describe all the delicacies. I have a question to Professor Goodwin-Gill, basically on something that you mentioned, which I agree with, but I would also like to hear your thoughts when you mentioned that the case law is inadequate to change some of the basically on what is happening in relation to the interrelation between the convention and EU law. And I agree with that. And you also mentioned that it's important to change the mindset beyond that. So I just wanted to maybe hear kind of more insight on that. And like a comment from me as well, because I think sometimes that the case law is aimed at changing the mindset. So when you were talking about pushbacks and pullbacks, sometimes it's not only about like what's going to happen, like how people like to call it strategically, but it's also just like the fact that this judicial proceeding exists, that this case law exists, that actually means that like we're not tolerating these actions by the state. So it's, of course, it's like one of the dimension. But I just wanted to ask you to share more thoughts on what else we can do to change the mindset.
That's a very good question, actually, and I don't have the answer. I mean, to some extent, it was a counsel of despair. I just do not know what's to be done without a radical change. It's the same as it is here in Australia. I do not know what we can do to change the government any longer, apart from a revolution, and no one seems inclined to get off the beach. So I don't have the answer to your question. I think, though, we've got to find some method in which we can, I mean, assume there are good people in the system. I know there are good people in the system, to bring them to the fore. I've always thought at the moment that for a long time, I've thought that the trouble is that too much power, too much influence is vested in ministers of the interior, ministers of justice, and not enough in foreign affairs. I don't know whether that's the case or not. It's a feeling I have. Whether those sort of interests can be brought to the fore in order to readjust the approach which is adopted by European states in relation to both migrants and refugees, and to approach it when looking at other countries from a perspective of promoting equity and fair sharing, but not only with regard to Europe and its member states, but also more naturally in the broader world. I don't know. It's my hope. I know that's not an answer.
It's as good an answer as we probably can get. I would still add that, Julia, you are with ECRE doing an important part of the job with strategic litigation and attempts at taking the right cases to the court in order for it to evolve. We all know that there is an art and science to this, and take the wrong case to the court and you will get what may be a setback that for refugee rights that lasts for years, and then take the right case and you may have a breakthrough. MSS is kind of a good example of that. It was, or Tarakel is another example of cases. I only have ideas from the ECHR, and perhaps that does something. But anyway, there were some interesting cases that were taken up and that helped make mentalities evolve. So it's very complex anyway. You got several levers, none of which does what you want, but perhaps they all inch you towards something better, not a solution, but something better. Walter Brill has raised a hand, and I would like to give him the floor immediately.
Yeah, thank you very much, and thanks for everyone's contribution. Really a very interesting discussion. I'm trying to look at this from a bit of a broader historical perspective. I recall that in the 90s, one was concerned, will there be harmonization on the lowest common denominator? I think if we look at it now, that was not necessarily the case. I think I would tend to agree with what Fabienne has said, and I think Julia also pointing at. Perhaps we are looking more at sort of a complementary between SEAS 1951 convention, because from my perspective, the crisis that we are seeing is a bigger one. It's even one that is bigger than refugee law. We are looking at the crisis of international law. We are looking at the lack of respect of law and rules for law. And whatever issues there may be, where we have different interpretations between 51 Convention, UNHCR, and SEAS regime, they have all in common the aim to have the respect for rules and for law. And for those of us who studied, European law again back in the 90s, wow, European law, this was supernatural, supranational, this had to be applied by everyone, no exception allowed. This looks very different. And if you look at that, what UNHCR has achieved with a lot of, convention that is 70 years old, and a lot of non-binding articles is absolutely amazing. So if you compare this regime with a supranational regime, I think the outcome is still a good one. But my point was that we need to have a broader perspective. We need to look at it globally. Europe here with its values can play a role in guarding the rule of law. And I say this a bit provocatively. Maybe it's not then the nitty-gritty of that part of the directive which is not entirely in line with a certain interpretation. So that was basically my main point. If I still may, a very brief question maybe to Anja and to Nicolas from EASO. My worry is more now in the practical area, where how UNHCR and the EASO in the future will work together. I've worked for an agency, for instance, that worked very closely with UNHCR in Greece, where also EASO is very active. That agency also in Turkey, where EASO is very active in terms of resettlement. I'm a little bit worried about UNHCR's future operational role and how that will come together with EASO. There is a bit of a risk that EASO may push UNHCR aside operationally. So that's maybe I'd like to hear comments. Sorry if I was a bit longer. I want to make those 2 points.
You were absolutely to the point. Thank you very much for your comments. I would refer that immediately, first of all, to Nicolas Jacob, and then anybody else who may want to comment. And I would ask him not to comment only on the last part, which is extremely interesting, the relation between your body, which is a regional body to support and promote good practices on EU asylum law, and the relation with UNHCR. That's a very salient issue, and I definitely would like to hear you about this. But I would also like to ask you, do you feel that there is a rule of law crisis in the EU affecting not only, but also asylum matters? And how do we come out of it? As an EU lawyer, I find this as a fascinating subject because, like Mr. Brill, I studied EU law when EU law seemed to be, you know, the Rolls Royce of international law, the only part that is, you know, surefire way to have it respected. And I look around and I see that the limit of the EU not being a federal state, not having coercion, not having anything like this, which was before a theoretical problem, has become a real problem. Is that something you see, you relate to? So two questions from Brill to me to Mr. Jacob, and then Anja, of course, may come in whenever she wants.
Thank you, Francesco. I mean, of course, I would like to hear Anja also on this after. Maybe then first on the more general rule of law. I mean, and thank you for this comment. And because you know, just it sounds very, I mean, how to say, familiar to my ears. I mean, just because I mean, here at EASO here, which is where I'm working with judges. We are working in the field of international protection across all EU and as well the both European courts. And this concern has been raised several times in such fora, actually. You know, it's because, you know, it's also the role, I mean, at EASO, sorry for the terminology somehow, but we call the asylum determining authorities the first instance and the courts and tribunals the second instance, which is from a continental, at least continental point of view, a bit strange, but whatever. So, but that, you know, just like that second instance is there, I mean, also like to shape further, you know, the law and just to have an impact on what the first instance is doing on the the very policies that are put in place. And that's, I mean, just, you know, it's more through the exchanges, I mean, you know, and just the very role of judges, and because, you know, just like when, let's say a constant, I mean, just a consistent case law on specific, you know, just is not actually respected or observed, that a judge sees the same case coming back and, you know, all the time. This is really concerning. And apparently, I mean, just that's, you know, in the last year, I would say, just, I mean, I hear that more and more often, you know, just talking also about really the role of judges, and also that, yeah, that fully agree that the rule of law is somehow, and not only, of course, in our field, I would say, under fire. Okay, so this said, just regarding UNHCR, I mean, the operational role, I think before underline the fact that EASO has not been designed as an operational agency. That actually, you know, the regulation is quite short in the article allowing EASO to take an operational role. I mean, they've been used quite, you know, extensively, let's say, just to say the least. And that's why also, I mean, it is in this prospect important to have the new EUAA regulation coming up. So now, I mean, again, I think like in you know, EASO, because it's new, this operational role, it's 2015, it's 2016, it's 5 years old. So it's very recent. And of course, I mean, it can create on the ground, you know, some tensions, let's say, or some difficulties, which is quite normal because you have a new actor arriving somehow. So, but for us, I mean, just then the key word is cooperation, and will remain so. You know, just is to try to best cooperate, and we see that in old operational fields. It's not proper for EASO or the UNHCR. There are many actors on the field, and finally, what we need to strive for is how to ensure, you know, that this cooperation is efficient, because I mean, you know, we need each other. That's for sure.
Thank you. Thank you very much. Anja, would you like to come in?
Yes, sure. on Walter's point, EASO Unhcr, I would like to say something which is more my personal position. I have a colleague from the office here. We have a colleague from the office in Malta here, so I would like to give Jeff the floor afterwards. For me, I would give Walter the same response as I give to colleagues when they ask me about Unhcr's role in a particular country. We are somehow, we are there to step in where we see gaps, where we see things not going the right direction. If EASO, we should be happy as Unhcr with having, and we have actually, I have been working on the first recommendations we made like 10 years ago on creating such an asylum office, because we saw it as an opportunity. Having a strong European asylum office for us, I think, should be an advantage, and if it allows Unhcr to step a step back and leave some of the tasks we had to do right now in the operational area to EASO, we can focus on other things. For me, it's important that we maintain our supervisory responsibility. We remain in dialogue with that office, and we make sure that obviously we are aligned in the vision and the prospect we have. So once obviously we see that there's an issue, we have to step in, but in first place, I think having a strong and well-functioning asylum office is an added value. I mean, that's my perspective, as I said. Let's see what Jeff is saying, whether he has a different position. Let me just, before I give the floor to Jeff, come to what Walter's point about the rule of law crisis. Yes, definitely, we definitely have generally a rule of law crisis internationally. With regard to, I don't want to elaborate on this because for us, it's maybe more important to focus on the EU context. And here I see two different things. One is, if we look into the reasons for non-implementation of existing standards, I see one reason is a lack of capacity and a lack of knowledge. So that's something I hope with a strengthened EASO and whoever you will be called afterwards could be addressed. And by better solidarity and cooperation among states. This can be addressed. What is more of concern to me is that the system we have in place and most norms we have right now in the CIS have been developed in the first phase of the ECRE and are based on standards in a part of EU member states. And what I see is that the vision behind these norms and the asylum systems of Western European states, the traditions, the values behind are not necessarily shared across the now enlarged union. That's the point that Guy made before about we have to change mindsets. And I think it's very important. Law is important, but it only functions if people believe in what is behind the law. And there, I think there's a lot of work still to be done to explain that asylum is a European value, and that's much more worrying. I think it's much more difficult to address than capacity gaps, which we have, and where I really think that EASO can do a good job if there. That's much more difficult to change mindsets and to create understanding for the importance to maintain an open Europe, also a Europe which provides asylum to people in need of it. But may I give the floor to Jeff, Francesco, if you allow me? Jeff is working in our office in Malta. Jeff.
I was preparing to do the same.
Thanks so much, Francesco and Anja. Yes, we have a liaison office to EASO down here in Malta. And yeah, I really echo what Anja said and what Nicolas said as well. UNHCR and EASO have different mandates. but at the end of the day, we agree on a huge majority of issues and points. Cooperation is obviously really important and really key. We work together quite a lot on a day-to-day basis across a whole spectrum of issues, not just operations, but myself, I'm in touch with Nicolas and his team quite regularly, and other areas to do with guidance and training. So not just operations, but we also have a working arrangement that outlines our cooperation and how we work together. And there is very much a focus on our reciprocity and us working together and cooperating. And what we really try and focus on is just avoiding duplicating, that we're not doing the same thing in parallel, that we can cooperate where we can cooperate, but also we can work separately, just avoid working on the same things. But there's plenty of work to go around. There's you know, there's a lot of space for both agencies to fill the gaps that have been outlined. Thanks.
Thank you very much. Thank you very much. I wanted to check whether there are any further questions among our participants or whether the floor is requested by anyone else. If that's not the case, I wanted to make the last round among our panelists for a very short statement, and Anja will take the opportunity to also add something. Unless you had a question, Anja, come in.
Sorry for taking the floor again, but I have one point which I really would like to discuss with you, because I mean, obviously, I mean, my intention with this lecture series was to give attention to the 51 Convention and the standards that have been developed 70 years ago. And my question to all of you is, how can we further strengthen the knowledge and the importance, I mean, the use of the 51 Convention? Because even where I see that we have standards developed in Europe on several things, like we have the ECHR, we have the CIS, they are not covering everything in the 51 Convention. So how can we broadly, you know, maintain that body of law and bring it to people's attention, so that it's not just that it continues to inform the space in Europe? And that's a real question I have. So I would be really grateful for your thoughts on that.
Okay, I think that we can go with this question as our closing one. And shall we take the order in which we took the floor? And Anja, you will also be able to try to give an answer to your own question, or at least to articulate a thought. Or perhaps I will ask Professor Goodwin-Gill to take the floor first in our last round. Let's all be, please.
Yeah, well, on Anja's question, I wonder whether if you want to promote the convention, as I think you should do, the time isn't right perhaps to translate it into English. To reduce it from its 45 articles to a short series of exactly what it is that the convention does, what it requires, who is a refugee, what rights they have, and frame it in terms of the convention, but without using the rather ancient language of the 1951 convention itself. I think maybe something could be done with that from a promotional perspective, is to translate it into modern English, modern French, modern German, and explain what it is that the convention does, for whom it works, and why. Thank you.
Thank you very much. Nicolas?
Well, I mean, just, I would say just like because, you know, EASO produces lots of, well, products, you know, practical tools, guidelines, analysis, country guidance, COI, and so on, which are more and more really very widely used by by the practitioners. I mean, but also asylum determining authorities and the courts and tribunals across Europe. So I think here, I mean, just it's something that should be, you know, but I'm not speaking here for the whole agency, but, you know, we do pay attention also for what, when it comes to what we do with the judges, that the link with the Geneva Convention, with the international refugee law is systematically made. That's what we can do at our modest level, I would say.
Thank you. Julia, you do already quite a bit for that, but say.
Yes, I think probably my response will be quite, I don't know, self-beneficial in some way. So firstly, we do try to, so I think it's just, I agree that it should be addressed in a number of levels, and I think it will be in relation to what we're talking about, the legislative and executive powers. I think it's really important for them to understand what it is, like, so that all the new measures, and for example, in some countries that like adopting a measure after measure, even before you manage to litigate the previous measure. So I think they should also be quite, yes, I think it should be kind of translated into a very kind of popular language for them to understand what it is and why they should comply with it. In relation to judiciary, I think you're already doing it and we're already doing it. So for example, and I actually see it like from time to time, for example, we are doing the LMA courses that are purely on refugee convention, and we see quite a lot of interest in that, and we actually see quite a lot of actually gratitude by lawyers and judges and decision makers who are saying like, well, it's great because we forgot that it exists. We also try like also to promote it in the intervention, and it's great, of course, that Unhcr is doing it, and like just a comment to Francesco on Dublin litigation and also on safe third country litigation. Of course, we advance the point on the Geneva Convention, but the way these are picked up by courts, I think it's a different thing. So I think just like maybe a bit more training on that, it could be useful. And I actually noticed even this year, and we were trying to do it together in partnership with you, like on the strategic partnership, that we even got the request from the domestic lawyers to do a short series on the events, specifically on the international human rights and refugee law, because now everyone thinks that, like everyone feels that it's missing. So I think just maybe continuing with that, and like in relation to what Nicolas mentioned, we of course the part of the group that is commenting on some of the EASO documents, and I really find it amazing that UNHCR is there trying to fight for kind of reintroducing the guidance and the convention. And I think it's really important to see it in the guidance. So.
Thank you very much. I will also try to respond to Anja's question as a way of closing. It's a very complex question, and it's one that you know elicits answers at many levels. But I would start from the fact that the drafters of the Geneva Convention did not put any army divisions at the disposal of UNHCR or at the disposal of the refugee protection system. So you cannot go by any other way than persuasion and awareness, because these are the tools of the trade for an international agency, whereas power rests still in the hands of the state. Okay, so there's this first fundamental question. Now, as to how do you raise awareness, awareness is something that happens on many different levels. And I agree with Professor Goodwin-Gill that on some level there is a failure to communicate to a wider audience why it is worthwhile to protect refugees, who they are in our understanding and what their rights are. But we should all be aware of the fact that the more you target the public at large, the more this is intensely political, meaning the idea that we can all just raise the awareness of who refugees are and then everything will go well kind of hits on the fact that there are political parties, political movements, etc., who created a political fortune in creating anti-refugee movements. Okay, so it's really deeply political, and it's not something that can be just done with technical promotion. We need that, And we also need to have, you know, political movements that support the idea of universal rights for all human beings, and the idea that the fact that we were lucky enough to be born on a peaceful continent does not divest us of our responsibility to our fellow humans who were born in less fortunate circumstances. That's very political, and we need to have real societal discussion on this all the time, because otherwise the idea dies out very quickly. And if we talk on a more technical level, and if we come back to our subject with the relation to the common European asylum system, as an example of a broader problem, we need to do all that we can all the time to avoid the Geneva Convention from becoming a museum piece, you know, the showpiece that is shown to the family when they come over to dinner and they say, oh, there's the Geneva Convention there in the nice dining room, and it's been there for ages. It's so nice. Let's sit down and have our business. The idea is that it's got to be mainstreamed. Every time that the European Court of Justice discussing issues that are relevant to the Geneva Convention, it should devote paragraphs to how it is interpreting EU law in relation to the Geneva Convention, because the treaty requires nothing less than that. And this is a big cultural fight, because the European Court of Justice is fighting other battles, and member states are fighting other battles, and EASO is fighting other battles, etc. But unless we manage to mainstream this into the reasoning, we are not going to be able to let the convention have traction. And here is my very short response to something that Walter Brill pointed out earlier, which is highly relevant. He made the distinction between fine points of interpretation and, you know, the dramatic and bleak reality that happens when migrants cross forests in the Balkans and get subjected to all sorts of violences. And I do see myself the difference between, you know, discussing somewhat ethereal issues of refugee law in the nice court halls and the grim reality of pushbacks at sea, etc. But it all is part of the same thing. It all is part of the same reality. If we don't promote a culture at the highest decision-making levels in which the Geneva Convention is a hallowed cornerstone of what we do in terms of policies, the end result would be violence on migrants, illegal violence, abuses of governmental authority in the forests of the Balkans, just to take an example that is very current. It's all part of the same effort, and we're all part of it, and we need to every time make the effort that is required to mainstream these preoccupations into whatever asylum policy issue is at hand. Very hard to do, but there is no other way, I think. So I don't want to be the last one to speak. I want Anja, who was my co-organizer, to also share in the last words. I was very happy to exchange ideas with all of you. I could not be more grateful to Julia Zelvenska and Nicolas Jacob and Professor Goodwin-Gill, and to you, Anja, for making this a reality, and for everybody, including my own team, Gael, who is showing here, my assistant Gael Perrault, and Ricardo Durigon, and the people here at the chair who worked for this, and to all of you who attended. Anja, I leave you the floor as the representative here of the Refugee Agency worldwide.
No, I'm not, unfortunately, not the representative of Unhcr worldwide, but thank you very much to everybody here on the panel. Thank you for your thoughts. Thank you also for this lively discussion, which I really enjoyed, I have to say. And colleagues, and in the audience, you have heard the suggestions on how we can keep up the 51 Convention, from Guy's proposal to simplify language, to Julia's proposal on training, and Francesco to mainstream the 51 Convention and avoid its becoming a museum piece. So please, I hope you are taking up these suggestions, and I would be super happy if I hear from you what you when you have taken up some of these suggestions. Thank you so much.
Thank you to everybody. Thank you so much.